The first rule is Rule 8, and I would like to read it. The heading is Rulings. The Speaker must perform the functions as provided for in these rules and may make rulings in applying and interpreting these rules, orders of the House and directives and guidelines approved by the Rules Committee. That is 8, subclause 1. But there's also Rule 4, which gives the power to the Speaker to suspend or supplement any rules as he deems fit for the House at that specific time. In addition to that, Rule 26, subclause 3, which is the general authority and responsibility of the Speaker, it clearly says the Speaker is responsible for the strict observance of the rules of the House and must decide, my emphasis, on questions, which is also, which I can also provide the definition of questions, of order and practice in the House, such a ruling being final and binding as provided for in Rule 92. I also submit that Rule 92 is not of relevance at the moment. Then, in Rule 129, motion of no confidence, in particular, 129 subclause 3, it reads as follows: the motion must comply to the satisfaction of the Speaker with the prescripts of any relevant law. My submission is the relevant law is Section 57, subclause B, with reference to representative and participatory democracy, or any relevant rules and orders of the House and directives and guidelines approved by the Rules Committee before being placed on the order paper, and must include the grounds on which the proposed vote of no confidence is based. In principle, according to the Speaker, she's got no objection to a secret ballot vote. In addition to that, the papers is very clear that none of the political parties in Parliament that will participate in that motion of no confidence has objected to the secret ballot application from the UDM. So if none of the political parties have objected, those ones that will be directly affected, why then are we still wasting time? But in addition to that, let me elaborate on the elements of participatory and representative democracy. And I rely on Theonis Roux. It's part of the Heads of Arguments in his article about democracy, and he describes it as follows: participatory democracy is essentially about the question whether, and if so, how citizens should be given the right to participate in the making of decisions that affect them, notwithstanding the fact that basic form of political organization in the modern nation state is and likely to remain representative democracy. So why the interpretation of the rules? My submission A is because members of Parliament performs a dual function in the performance of their duties. They represent people, that is in Section 42, subclause 3, by passing legislation, choosing the President, overseeing executive action, etc. But they're also members of the political parties, and we cannot ignore that. Whether they vote with their conscience, which they should, there is also still the element of political party loyalty that they have to adhere to. So how best then can the Speaker find the common ground to accommodate these two notions? My submission is plain and simple: by allowing a secret ballot vote. Rule 35 of the parliamentary rules, in addition, also indicate that when a member of Parliament is absent, it is not the National Assembly that demands answers, but that member of Parliament should in fact report to the political party that he or she represents. So clearly, and we all know it is common, that the political parties play a big role, and we cannot just push that aside in the name of vote by conscience only. The authority for this is also derived from the matter Max versus Independent Democrats and Others, 2006, Volume 3, SA 112C. And that court has indicated that, 1, members of parliament perform a dual function. They represent the party and they serve in an individual capacity. But constitutional democracy is undermined if individual capacity of a member of parliament is not recognized. And this is what all the previous counsel before me have spoken on. Constitutional democracy is premised on a government that is responsive to the needs of citizens. What do I mean with responsiveness? It's reflected through an active participation of all the citizens, and that active participation is in essence underlined in Section 19 of the Constitution, and it is also referred to by Pierre de Vos in his article, It's My Party and I'll do what I want to. But my submission with regards to this is the citizens' voices are heard through, number 1, public hearings in Parliament, number 2, hopefully, peaceful protests, and number 3, the election of public representatives. So why then are their voices not heard when it comes to the secret ballot vote through a motion of no confidence?
The 10 minutes has expired.
I thought that was
so we are free to interrupt you. But let me ask you this question. You say no party is against the secret ballot.
Yes.
So why are we wasting time?
Yes, Chief Justice.
Why don't they make a rule now that they agree to vote by secret ballot rather than adding to the workload we already have?
I was hoping they're going to do that before we start, Chief Justice. May I continue? Thank you. At the end of the day, it is the citizens that bear the brunt of whether the motion of no confidence will succeed or not succeed. We all know about the notion of #junk status. The exercise of political rights of citizens cannot be interpreted to participate in public hearings, in protests, public protests, etc. But when it comes to a decision like a motion of no confidence, all of a sudden they have waived their political rights to participate. And what is the effect of a waiver then? We must look at the nature and purpose of the right. It is my submission that when it comes to Section 102.2, this is something serious. It's got to do with the oversight of the executive. If we say that the citizens cannot participate through a secret ballot vote of the members of parliament, then we also need to look at the length of period that they now will have to suffer, irrespective of the outcome. But also, what is the danger of the abuse? The danger of the abuse is seriously that it will impair the constitutional democracy, where it clearly says that members of society can participate in any decisions that directly have an impact on them. The Leonard Max matter also indicated that members of parliament, despite being appointed through a party, can follow their conscience. That is what the previous members have said. But in addition to what I've said, a motion of no confidence is not just members coming to one venue, which is the National Assembly, and vote. There is a debate. And that debate is clearly set out in the rules. And my submission is that, of course, a debate is not just members talking, but it is there because it's got a persuasive value. And why would there be a debate if the Constitution and the members of Parliament and everybody was of the view that we will just go there and quickly get it over and done with? My submission is there is a debate so that individual members of Parliament can be persuaded to vote either left or right. But there is also the reality that there is bound to be a time conflict between faithful to the Republic, which is part of the oath of members of Parliament, and the loyalty to the party. We cannot run away from that, and it is then the responsibility of the Speaker to find the middle ground when it comes to that. In the Mazibuko matter, paragraph 41, the court clearly held that voting on a motion of confidence is done by members of the Assembly collectively. Not political parties, members collectively. The presence of threats is there, whether we want to address it or not, whether we do not recognize it or not, it is there, and I would like the court to take judicial notice of that. But in the matter of DA versus Speaker, it was held that for Parliament to exercise its oversight function over the executive, it must operate in an environment that guarantees members freedom from arrest, detention, prosecution, or harassment of whatever nature. Absent this freedom, Parliament may be cowed with the result that oversight over the executive may be illusionary. It is my submission that when we leave at the end of this day, we shall be clear and confident that when our members of Parliament vote, all these rights that I've indicated to now will definitely be present. Again, the question was asked earlier, why are members not free to vote in an open vote? My submission with regards to that is the element of dual representation. They represent societies. Society is voters, non-voters, members that have all citizens, and it's not just members of a particular political party. And if the members will now go and vote on an open vote, and where there was a political party that have already pointed the finger towards some of their members, then unfortunately the conclusion would be that it is not the rights of the citizens that have trumped, but in fact it would be that of the political party representation instead of that of the members. So the voices of citizens would have been silenced. In the Leonard Max matter, again, the court warned against voting cipher. I hope this will not be the case. But also, again, I refer to the matter of DA versus the President, where it was held that no confidence is directly linked to belief. Justice Cameron also referred to that earlier, belief. When members vote for the President, they have to believe that this is the right person to lead this country. And so when it comes to a motion of no confidence, it's again that issue of belief. And we cannot say that political parties have beliefs. That is ascribed to individuals and not to political parties. There are no emotions when it comes to political parties. In the Ambrosini matter, I'm almost done, Chief Justice. In the Ambrosini matter, paragraph 65, the court held that the validity of the National Assembly rules depends on whether they recognize and facilitate the exercise of the individual's members' powers. Alternatively, whether they create a high risk of those powers being paralyzed. So in short, the answer is that when the Speaker received the letter of the UDM, she ought to have taken into consideration all these cases that I referred to, Section 57 with regards to participatory and representative democracy, and then she ought to have made a decision keeping in mind that the National Assembly is there to represent the people on the one hand, but also the members of Parliament are linked to the political parties that they serve. And in order to come to the middle ground, the only conclusion that we can get to is a secret ballot vote.
What should he have made of the Tlowama judgment?
Chief Justice, when that matter was passed, it was a different political environment in this country.
No, I'm asking about the binding effect of a court judgment, political environment aside. Here is a Tlowama judgment that tells me as the speaker that there is no room for a secret ballot when it comes to a motion of no confidence. What is the speaker supposed to do? Disregard.
Chief Justice, I'm not so sure now exactly the date when the Tluama matter was passed, but I do know that the rules of Parliament was recently adopted, which was on the 26th of May 2016.
Yeah, but my point is this. Did Madam Justice Goliath and her colleagues interpret the rules only or the Constitution as well? Section 102. For us to say the correct interpretation depends on whether you are looking at the old rules or the new rules.
Chief Justice, there's more than enough room for interpretation in the rules that could have allowed the Speaker to find the middle ground in order to make sure that the rights of the citizens is protected the same way that the political parties' loyalty is also protected.
That I understand. I'm saying you are a speaker, you have the Tluama judgment. And the Tluama judgment said, no. You can't. You can't have a motion of no confidence voted on by a secret ballot. What must she do?
She could have called for an urgent sitting and allowed the parties to vote on it. In any event, when she noticed that none of the political parties in this specific matter objected to this application, she is the chairperson of the House. She knows how to interpret the rules. She could have then said that she abide by the outcome of this court, alternatively that she grants the request, because in any event, the affected parties have no interest in this matter. My submission is, unless the element of dual representation of members of Parliament is incorporated in the rules, the motion of no confidence will just become a paper power and not really the power that we have envisaged in the Constitution. In the Mazibuko matter, even though it was part of the minority judgment, paragraph 45 indicated the better view of this right is accorded to every member of the National Assembly. So everything points towards the rights of individual members. Of course, that relates to conscience, but my submission is, in addition to that, the rights of the citizens must, at the end of the day, prevail. I would like, in conclusion, provide this court with something to think about and take judicial notice of it. I can provide this information. It's just a few numbers. On the 6th of May 2009, Chief Justice Langa was the presiding officer at Parliament when 393 members of Parliament were sworn in. Then there was a proposal that Mr. Jacob Zuma become the president, and there was a counter proposal that Mr. Dandala become the president. The result of that was that Mr. Dandala got 47 votes and Mr. Zuma got 277 votes. Now remember, I said earlier, 393 members were sworn in. They were in the House. The election took place. And then the result came, 324 members voted by secret. We don't know who voted how, but at the end of the day, the minutes reflect that 69 members of parliament did not vote. We don't know who those members of parliament were, from which political party. I cannot elaborate on that. But the issue that I would like to leave this court with is, if in 2009 there were 69 members that was not held accountable, and we were all happy, we got a president after the elections, why would this now be an issue? Thank you, Judge.
Thank you, Ms. Adams. Thank you very much. Mr. Bartlander, I think you're next.
Two.